You can be handcuffed, placed in the back of a police car, and held for 40 minutes without being arrested. That sentence will change how you see every police encounter for the rest of your life. This happens to ordinary, law-abiding people every single day across the United States, in Texas, in Ohio, in California, in your state. Most of them walk away thinking they have a criminal record. Most of them are wrong. By the end of this video, you will know exactly what happened to them, why it matters, and how to protect yourself if it ever happens to you. The Department of Justice has documented tens of millions of police-civilian contacts occurring in the United States every single year. A significant portion of those contacts involve detentions, not arrests. But almost nobody knows the difference. It is not taught in schools. It is not printed on your driver's license. Nobody hands you a card explaining your constitutional rights when you turn 18. The system assumes you already know. You do not. And that gap between what the law actually says and what people believe in the moment costs people jobs, opportunities, and years of anxiety over something that was never on their record to begin with. Tonight, two men are going to have the exact same police encounter in the exact same neighborhood. Only one of them knows the law. Watch what happens. The foundation of everything you are about to see is the Fourth Amendment to the United States Constitution. Ratified in 1791, it protects every American from unreasonable searches and seizures by the government. That word, seizure, is critical. A seizure does not only mean an arrest. It means any moment when a police officer restricts your freedom of movement. That distinction is where most people lose everything. In 1968, the United States Supreme Court decided Terry v. Ohio. That case established something called an investigatory stop, commonly known today as a Terry stop. Here is what that ruling actually means. A police officer can temporarily detain you, stop you, question you, even pat you down, without arresting you and without probable cause for an arrest. They only need what the court called reasonable suspicion. Reasonable suspicion means specific, articulable facts that suggest criminal activity may be occurring. It is a lower bar than probable cause. It does not require proof. It requires a reason. What this means for you: an officer can legally stop you without intending to arrest you, and that stop, by itself, creates no criminal record. Now here is where most people go wrong. A detention and an arrest are two completely separate legal events. A detention is temporary. It is investigatory. It can last only as long as reasonably necessary to confirm or dispel the officer's suspicion. An arrest is a formal taking into custody. It triggers booking. It triggers a record. It requires probable cause, a significantly higher legal standard. Handcuffs alone do not mean arrest. A patrol car alone does not mean arrest. 40 minutes of being held does not automatically mean arrest. What this means for you: being handcuffed during a detention is legal under certain circumstances and does not equal an arrest on your record. This next part is critical. In 1966, the Supreme Court decided Miranda v. Arizona. That case established that once you are formally arrested, law enforcement must inform you of your rights, your right to remain silent, your right to an attorney. But Miranda rights attach at arrest, not at detention. During a Terry stop, you are not automatically entitled to a Miranda warning. This is where silence becomes your most powerful legal tool. You are never required to answer questions beyond identifying yourself in states that have stop and identify statutes. In those states, which include Texas, Nevada, and Utah among others, you may be legally required to provide your name, but nothing more. What this means for you: during a detention, you can and should remain calm. Identify yourself if required by your state, and say nothing else without an attorney present. In 2004, the Supreme Court addressed this further in Hybel v. 6th Judicial District Court of Nevada, confirming that stop and identify laws do not violate the Fourth or Fifth Amendment, but only for a name. Not your address, not your destination, not your history, just your name. What this means for you: knowing your state's stop and identify law before you ever face an encounter could be the single most important piece of legal knowledge you carry. It is 11:15 on a Thursday night in Houston, Texas. Two men are walking home from the same convenience store 2 blocks apart. Marcus is a 26-year-old warehouse worker. He is carrying a bag of chips and a phone charger. Daniel is a 24-year-old community college student. Same bag, same block, same neighborhood. Same patrol car sees them both. The officer pulls over and approaches Marcus first. Marcus is nervous. He starts talking immediately. He explains where he has been, where he is going, and who he was with earlier. The officer says the area has had recent vehicle break-ins. He asks Marcus if he can look in his bag. Marcus says yes. The officer finds nothing, but during the search, Marcus mentions he was near a car earlier in the night. The officer detains him, handcuffs him for officer safety, and places him in the back of the patrol car. Marcus is panicking. He keeps talking. He volunteers information. 40 minutes later, he is released with no arrest, no charges. But for 6 months he believes he has a criminal record. He does not apply for a promotion. He does not finish his job application. He spends money on a background check service out of fear. All of it unnecessary. Now let us rewind. Daniel is approached by the same officer 20 minutes later. Same questions. Daniel speaks calmly. He says, "I am happy to identify myself. I do not consent to searches. Am I being detained or am I free to leave?" The officer confirms the detention. Daniel remains silent beyond his name. He is held for 11 minutes. The officer confirms no reasonable suspicion can be developed further. Daniel is released and walks home. He never loses a single night of sleep. Same night, same street, one conversation, two completely different lives. The first mistake Marcus made is the most common one in the country. He volunteered information before he was ever asked a direct question. People do this because silence feels guilty. It does not look guilty to a judge, but it hands the officer tools he did not have before you opened your mouth. The second mistake is consenting to a search. Officers are trained to ask. They ask because consent removes your Fourth Amendment protection entirely. You do not have to say yes. Most people do not know that. Saying no is not obstruction. It is a constitutional right. Even more dangerous is continuing to talk after a detention begins. Once that stop is initiated, everything you say is being evaluated. You are not having a conversation. You are generating evidence. Silence is not rude. Silence is protected. Here is one almost everyone gets wrong. People assume handcuffs mean arrest. They do not. The Supreme Court has held that handcuffing during a Terry stop can be lawful for officer safety. Believing you are already arrested often causes people to give up entirely and start confessing to things they were never going to be charged for. The final mistake is not asking the single most important question of the entire encounter. Marcus never asked if he was being detained or if he was free to leave. That question forces a legal answer. Here is your practical toolkit. These are real words you can use in a real encounter. The moment an officer approaches and begins questioning you, say this: "Am I being detained? Or am I free to leave?" That question requires a legal answer. If you are free to leave, leave calmly. If you are being detained, you now know your rights apply. If an officer asks to search your bag, your car, or your person, say this: "I do not consent to searches." Say it once. Say it calmly. Do not argue. Do not explain. One sentence. If an officer asks you questions beyond your name, say this: "I am invoking my right to remain silent. I would like to speak with an attorney." In Texas and other stop and identify states, provide your name. Nothing else. If you are placed in a patrol car, do not speak. Do not reason with the officer. Do not try to explain your way out. Wait. Cooperate physically. Stay silent legally. Using these words is not aggressive. It is not disrespectful. It is the behavior of someone who understands the law, and that understanding is exactly what protects you. Here is what you now know that most Americans do not. A detention and an arrest are two separate legal events with two completely different consequences. Terry v. Ohio gives officers the right to stop and briefly detain you on reasonable suspicion alone. Handcuffs and a patrol car do not equal an arrest, and do not equal a criminal record. You have the right to refuse searches. You have the right to remain silent. You have the right to ask if you are being detained or free to leave. And in Stop and Identify states, your name is all you are required to give. Marcus lost 6 months of his life to fear about something that was never on his record. You will not. This video is for educational purposes only and does not constitute legal advice. Laws can vary by state and by individual circumstances. If you are facing a legal situation, please consult a licensed attorney in your state. If this helped you, someone you know needs to hear this too. Share this video. Send it to someone who has never thought about what to do when a patrol car pulls up beside them. That conversation could protect them from months of fear over something that was never real. Subscribe so that the next time you face a situation like this, you already know what to do. Knowledge is the only thing they cannot take from you,